Okay, good evening. Welcome to the webinar on probate and deceased estate administration. So I suppose a lot of people only do this maybe once or twice in their life, and you probably don't learn about it or look into it until you're either one, asked to be someone's administrator, or secondly, all of a sudden someone's passed away and you don't know what to do. So let's get into it. If you do have questions that arise during the webinar, by all means put them in the chat box. For those watching the replay, there is a Q&A button on the page which will email me and I'll get back to you within 24 hours. So who am I? My name's Jackie Broman. For those of you who don't know me, I own TBA Law and I'm an accredited specialist in wills and estates. So I'm a solicitor first and foremost, which is a type of lawyer. So solicitors and barristers are all lawyers. Solicitors are the lawyers who work directly with clients, whereas barristers tend to be subcontractors to lawyers and work mainly in court work. To become an accredited specialist, I also did my master's degree in wills and estates, and then the Law Institute has a 12-month accreditation program, so you do that and more exams. And why we put ourselves through this, I don't know, but there's only about 80 wills and estates specialists in Victoria, and there's about 22,000 lawyers all up, so there's not many of us. But I am also a human, despite being a lawyer. And on the other side of the screen, you can see there two of my passions. I love my dogs, and that's one of them there. He needs to be chained up on the boat because he loves to chase water and it wouldn't be great if he jumped over. And so I also do a lot of fishing. That is my downtime. Unfortunately, at the moment, not much recreational activities happening. But hopefully we'll get back to normal life soon enough. So all that being said, let's get into some of the main content of what I wanted to talk about tonight. So when someone passes away, it's not that solicitors often find out quickly. However, I know that people can get themselves quite distressed about whether they think they're doing the right thing or not, pretty much as soon as someone passes. So if someone is unwell and they're expected to die and they die at home, you don't need to call the ambulance. You can just take your time and call the doctor that knows of the situation. If you call the ambulance, it takes you down a whole nother path, and you might not get much of a chance to sit with the body of your loved one again after that. So just, I suppose, a quick tip about what to happen when someone actually does pass at home. The funeral home often takes the body fairly soon unless a coroner is involved. And you quite often have to select a funeral home fairly quickly. Now, if you do that and quite often you're not in a great state to be making decisions, and then you change your mind a couple of days later, that's generally fine because funeral homes can transport the body between themselves. There's sometimes a transfer fee, or often is, but don't think that you're locked in to a decision that you made quite quickly and suddenly while you were distressed. So from the funeral home, quite often you will get some of the medical information. So you will be able to get what is called the medical cause of death paperwork. And this is the main proof of death that you have until the death certificate arrives. And the death certificate can take 4 to 6 weeks or sometimes longer. If a coroner is involved, they won't issue you a death certificate until they've ruled on the cause of death, which could take months. But if the coroner does get involved, you can ask the coroner for an interim death certificate that doesn't have a cause of death on it. So you get this medical certificate as to the cause of death. So that, I suppose, is fairly important at that point. Now, often the funeral home will also advise Centrelink if Centrelink is involved. And they're the ones that send in the information to births, deaths and marriages. So that's who eventually issues the death certificate. Now, having a look at the will at this point can be important, and hopefully the person who's passed away has a copy of it at home. If not, hopefully you know who they did the will with, or it might take you a few phone calls of local solicitors to find who did it, unfortunately, because there is no central register for all wills. Only very few people actually lodge their wills with the Supreme Court because it's not something that's compulsory, and in fact it's not something that I would generally recommend either. So quite often you've got a bit of a job of going through some paperwork fairly early after someone's passed away to see if you can find the will. Now, there is no reading of a will. It's an American concept. It's in the movies, but that is not a legal requirement. It is not generally done in Australia or any of the Commonwealth countries for that matter. Now, the thing that's important about the will at this point is firstly to determine who the executors are, if it wasn't commonly known. The executors actually control the body of the deceased person and what actually happens to that body in terms of burial or cremation. And sometimes the will have that instruction in it. If you do the opposite to what the will says, it can actually be a finable offence. If the will says that the person is not to be cremated and you end up cremating the person, you can be criminally responsible for that. So the other thing that the will might have as well are some instructions about funerals. Generally, those instructions are not binding, but it's a nice thing to do, really, to follow the wishes of someone who's passed. So at that point, that's probably all the will is good for, because there is not much that you can do after that until the death certificate comes. So the other job of the executor up until the death certificate arrives is to secure the assets. So that can mean changing the locks on a house, for example, because it happens all too often that people know where the spare key is and they'll go in and things will go missing, particularly cash and things that are easy to pick up and move. And unfortunately, quite often it's family members who do it. So it is the responsibility of the executor to do that, to secure any assets. Also, you know, if a vehicle was elsewhere, just to make sure that it's brought back home. And it's also worthwhile, while you're going through paperwork, to work out what the insurance policies are, work out what banks are involved, and whether there's any financial planners or other major investment institutions, essentially. So it's good to start, up until the death certificate arrives, collating some of that information. So I suppose that's immediately what happens on death, the first week or two up until the funeral, and then essentially the first 6 weeks up until the death certificate arrives. Then the death certificate. So if there are people who didn't know, I suppose, about the person who has passed away, you're not compelled to tell everyone, particularly if they're not beneficiaries in the will. So at this point, the executor, if they haven't already, goes to the solicitor, takes the death certificate, and they have a more formal discussion about what is happening next and what's in the will. So those entitled to a copy of the will are any beneficiary in the will and anyone who would be a beneficiary if the person had died without a will. So that's essentially any spouse, any children. So if someone in that category asks for a copy of the will, you can't refuse it. You have to give them a copy. And at this point, we also generally write to all the beneficiaries and give them a copy of the will, just so they're aware. At this point, we're also working out whether probate is needed or not. So probate is the process of giving the will to the Supreme Court to get them to essentially confirm that it's a valid will and endorse that the executors are allowed to proceed with administering the estate. You do not need probate in every situation. So that's why it's worthwhile working out whether you do or not, and a solicitor can help you with that. So, for example, what are the situations where you wouldn't need probate? So quite often when the first out of a couple passes away, most of the assets are probably joint. So in that circumstance, joint assets transfer to the surviving spouse without too much of a problem, and certainly without probate. So joint assets would mean there's no probate. The other situation would be if there's very little money. So there might be superannuation. That doesn't necessarily need probate. Depends on the fund, depends on the binding nomination, if there is one. If there is less than $50,000 in the bank, no probate needed. So it's, I suppose, working out what you can get away with without having to do the probate. And sometimes what needs to happen at this point is just writing to all the asset holders, all the banks, the super funds, and saying, okay, this person has passed away. What are all the accounts? What are the balances? Will you need probate, or will you let us deal with it without probate? So that's then the process. If we work out that probate is needed, we just start collecting the information to get the probate application together. Now, unfortunately, it's a lot of people's experience that it takes a long time to get probate, and that shouldn't be the case. The death certificate takes 6 weeks, and then once the death certificate arrives, it may take another up to maybe 4 weeks to work out what's in the estate and what everything is worth. However, once you have that information, the probate application should not take very long. And then it's as quickly as you can get the probate application signed. Probate is taking less than 2 weeks in Victoria at the moment, because as at the 1st of July, we're now filing everything electronically. So they're getting everything very quickly, and they're reviewing it quicker than they've ever done before. So the final thing there as well is around debts. So a lot of executors are worried that the debts will end up being their debts, or they'll be responsible for them. So it's not necessarily the case if the executor is careful. The debts of the person who's passed away should just be locked in the estate. So sometimes if there are more debt than assets, the estate is an insolvent estate. And for example, banks have to write off credit cards because there's just no money, like they're just not going to get it. So long as the executor finds the debts and informs the person that the person has passed away, generally they're fairly safe from the debt becoming something that they will be liable for. Tax debts often get priority, so you have to be careful there with the tax office. Make the inquiries there as well, particularly if the person's still working when they passed. And the other thing to be careful of as well is any debts that you don't know about. So what we don't want to happen is the executor to get all the way through the estate administration and divvy out everything and distribute it all to the beneficiaries, and then someone who's owed money popping their hand back up and saying, oh, but you know, I was owed 10, 20, 30 grand. And in that situation, the executor would become personally liable. So the people that are owed money need to be informed that the person has passed away. So the way you get around that is, if you are worried, particularly if the person was, you know, not of retirement age, they were still active in life, they were still doing a lot, they may have been in business, is to put an ad, and there's a way of doing it. So it goes in the Government Gazette and a couple of other papers, a printed ad calling for creditors who are owed money to come forward. They have 2 months to do it. If they don't do it, too late, so sad, they're not getting anything. So that's the way an executor protects themselves from debt. And you do it at that point because it's not conditional on probate. Get that 2 months over and done with as soon as possible so that that clock expires and you can deal with the estate. All right. So the person's passed away, you've done the funeral, death certificate's arrived, you've worked out you need probate, probate application is done, and then we get probate. So now we go about closing bank accounts, transferring assets, might be real estate, might be shares, contacting super funds to get the death benefit paid. All those things happen. So we collect everything in. Claims. So we also at this point work out whether there's any potential for anyone making a claim on the estate, whether there's anyone who even falls in the category who could make a claim, because now in Victoria we've got narrow categories, so it's fairly easy to work out whether there's someone who's going to come out of the woodwork or not. Those people who can make a claim are spouses and children essentially, or someone who's financially dependent. So it's fairly small category of people. So if, for example, you know, dad's passed away a long time ago and it's mum who's just passed away, and there was a house and some money in the bank, you would transfer the house to the executors and the executors would then sell it. The proceeds of sale would come in, the bank accounts are closed, they've all come in, you'd contact all your brothers and sisters, and it's still within 6 months of the probate, and you'd say, well, we're ready to distribute, sign off on this paperwork and confirm you're not going to claim, and then we'll distribute straight away. Otherwise, you would wait 6 months from the grant of probate. So again, just like with any debts that are owed by a deceased person, we don't want an executor becoming personally liable for a claim. So if the executor distributes the estate in the first 6 months and someone makes a claim, the executor can be liable to pay that claim out of their own pocket. So that's the 6 month time frame. If someone brings a claim outside of 6 months and the executor has distributed, it's too late for that person making the claim. So the 6 month time frame is important to keep in mind. So you can distribute the estate within 6 months if everyone agrees and they confirm they're not making a claim, or, you know, if everything was just pretty straightforward and there's no one that's going to make a claim, so there was only one child, for example, easy. Otherwise, you'd wait your 6 months. All the funds usually comes into a solicitor's trust account, or you can open an estate bank account. You do a statement of account so that everyone can see what's come in and what's gone out, and you do the proposed distributions so everyone knows who's getting what. They sign off on that. Done. So, I mean, that's a very simple, straightforward one. Obviously, the complexity of the assets that are held can cause things to take longer. Or if there are trusts set up, things can take longer. So the executor can end up holding things on trust for beneficiaries for long periods of time. So that can happen as well. The executor also needs to make sure that tax is taken care of just before everything's distributed on a final basis. If the person had been retired and not paying tax for a long time, generally they'd already done a final tax return, so you wouldn't have to do one for the deceased person. And then it depends with the estate whether there was any income earned by the estate, whether you need to do an estate tax return or not. So a lot of small estates, you don't even have to bother doing any tax because there is no tax liability. But if there are, a large share portfolio, or if there was real estate that was being rented out, doing a final estate tax return as well would be worthwhile at that point. Or if there's any capital gains tax to be paid on any of the assets. So the estate can pay that tax rather than the beneficiaries having to pay it in their own tax returns. So that's something else that's a little bit more complex, but I think what I'm going to do is pretty much open it up for questions, because I've gone through most of what I needed to, and you're going to tell me what I've missed and what you really need to know about. But what I've got on the screen there is a couple of downloads that are on our website. So if you want to write down that link, or you can take a screenshot, it's just our website, and it's then the sub page, wills and estate planning. So there's some free downloads on that page. There's the who to notify checklist. So on someone's death, it's a list of everyone that probably needs a copy of the death certificate. So you just go through that and work out, okay, if you've done it or if it's need to do or not applicable. I've also got a couple of different brochures there you can download. So one is for beneficiaries of an estate. It's about 5 to 7 pages long, and the other one is specifically for the executors of the estate. So for the beneficiaries, it talks about, how long will the estate take? What should I expect? How much involvement should I have? What sort of information have I got a right to see? And for the executors, it talks about, well, what's your role? What's your obligations? All that sort of thing. So please jump on and grab those too. If you struggle with that, just email me and I'm happy to email you those. That's easy. So let me have a look at some questions. All right. Yeah, just a comment about securing assets there. Yeah, it's sad when it doesn't happen. Sounds like a little bit of poor advice as well. Patricia, do grandchildren have a right to claim if their parent died before the deceased? So generally no, because you don't have a obligation to your grandchildren. So that has changed in 2015. So prior to 2015, grandchildren could potentially claim. Now they can't, unless there is a closer relationship between the person that has passed away and the grandchild that's more like a parent-child relationship, or if the grandchild was actually financially dependent on the grandparent. But otherwise, no, there's no obligation. However, the problem is that sometimes solicitors who aren't specialists don't understand that there's actually a catch in the law with grandchildren. So unless the will says otherwise, the law says that if a child has passed away before the parent and that child has children, the children will get the share of their parent. So that is actually what the law says. So if that's not what someone wants, they actually have to put it specifically in their will. So that wouldn't be a claim by the grandchildren. That's an entitlement, and their right to stand up for their entitlement. But if the will specifically excludes them, then no, they've got no claim. No claim. Alrighty. Thank you. Thanks very much. That's my email address there. So again, if you want to screenshot that or write that down, this webinar only went for just half an hour. So I hope that that was relevant information for you. I suppose I do tend to talk a little quick when I'm passionate about it. But I'm going to finish the recording. For those watching a replay, again, email me with any questions. But for those on live, just hold on after I finish recording.